I'm going to talk about general cases, what the courts actually tell you about the liability of brokers and best practice to an extent, and then Gary's going to drill down with real-time examples. Now, the one thing to understand about best practice is that it is actually higher than your legal duty. It's an aspirational standard. If followed, it really means best practice, that if you will always avoid legal liability if you have had best practice all the time. But the reality is about our lives is that best practice 24/7 is something that doesn't really happen. The real issue is being able to prioritise when best practice is mandatory and when you can actually maybe let your standards go a bit, or because you don't have the resources, you've got to make allocations as to when your resources have got to go, when best practice is mandatory. And what Gary is going to talk about is that where best practice is mandatory for brokers is around placement, renewal and claims. Now, I try to avoid sporting analogies if I can, but best practice, taking the best practice footballer around would probably be Gary Ablett. I saw him demolish North Melbourne the other week. He got soundly beaten by Levi Greenwood for 2 quarters, but still on the other end, when it counted, won the game 30 possessions and 4 goals. Didn't burn up his energy on the things that didn't matter, was absolutely focused in there when it did matter. Similarly, a pilot. I've got a few friends who are pilots. They're completely ridiculous people, like absolutely ridiculous people. But, you know, they say at takeoff and landing, they have absolute focus. And when they're turning off the transponder as well. But, so it's about putting the effort where it matters. Now, contrary to popular belief, I haven't spent this morning taking cocaine and seeing hookers like our friend Jordan Belfort here. But can I say I'm an absolutely massive fan of that movie for the fact that, and I think Gary and I do share another thing, we actually do come from a very strong left-wing background, and I thought it was one of the most vicious swipes on capitalism, and in particular the prevailing sentiment of the market about industries like yourselves that are commission-driven. And I don't know if people have seen that film, but there is this absolutely wonderful scene where Jordan Belfort is demonstrating to all these people how to sell penny stocks and completely stuff over your client to get them to buy some absolute crap so that you can get some commission. Now, it's not what best practice is about. Best practice really involves a very high ethical component. But, you know, there's no doubt about it, people who fall short of best practice can get lucky. Now, this is actually a true story. You can see the number plates there, 007 on a Rolls Royce. My mum worked in mental health for many years, had a mate from uni, a fellow called Fred, who was a very successful physiotherapist. He was the physio for the English soccer team for quite a while and for Liverpool for many years. And when he was in Harley Street, he was fortunate enough to start treating a recently widowed lady. And this is the car that her former husband drove. He took out he got those number plates as a complete joke when I think the first James Bond film came out. When was that? Does anyone know? And does anyone know which one it was? Dr. No. Dr. No was the first one, before From Russia with Love? And what year was that? 64. So before they had personalised number plates. Now, it wasn't the 7th Rolls Royce he had in the fleet, but this man was very wealthy. And that's parked out front of his house in Mayfair. Now, Fred started up a relationship with the lady he was treating. Fred at the time was 74, I think she was 73. And now they've shacked up together. They've got the whole 6th floor of that particular building. The 6th floor on its own is valued at £60 million. And he's got his own table at the Savoy, which is pretty good going for a physio. But Mum went and saw him, and they went out for a drive in that. And this is a true story. Roger Moore was walking along the front of Mayfair, and he stopped, tapped on the window and said, "You're driving my car." What do you think Fred just got offered for those number plates? £1 million, right? To buy the number plates. He said, "Stuff off. Got a lot of things I need in my life, but currently £1 million isn't one of them." So I said to Mum, "I'm really not that impressed with Fred's ethics, Mum." And he said, "David, do you think he gives a stuff?" No, absolutely he doesn't. So you can fall short of best practice and succeed. But what we're going to talk about today is some cases, and then Gary's going to get you into some cutting-edge examples. Now, these are all decisions from 2012 against brokers. Now, none of them actually concern financial lines practice. I could go back a bit to find some cases talk about some cases about breaking financial lines, but I just thought these recent cases are a really good example. Now, just understand how much you can actually take out of a decided case against a broker. First thing to understand is that 95% of claims against brokers will settle. right? So for something to actually go to a decision, there's got to be an unusual feature about it. And also we're talking about conduct. There's a huge lag time. So the conduct in relation to these cases usually occurred about 4 or 5 years ago before you get the decision. So there's a big lag time. So I'm going to talk about what the cases say about best practice and when brokers have been held to fall short of that. But Gary's going to talk about real-life claims examples now that are on the way to their courts or are going to be settled. Because the reality is the cases that actually end up a decision are the ones where the broker had a good defence. That's the reason they're there. If the broker was shot on liability, they would have been settled ages ago. All right? So let's just start with the first one. But the whole idea is you can learn a lot from others' misfortune, and the cases are still useful to show where the problems come from. Now, there's just a couple of qualifiers there. Doesn't concern financial lines, but the key messages are the same. Now, if you want to follow it, all of these case notes are set out in the paper that's attached. And if I could also just briefly take you to the very last page, which has just got a chart and a policy. And I'll come back to this at the end, but this is from another paper we did for ProRisk back in October 2012 for the words that matter. And it just runs through, the six key elements of a financial lines policy and the particular issues that can arise in relation to them. Now, the key message I've got about all this is that this is what your client has to understand about the policy, right? And where the differences are. And using that diagram can be an extremely good discipline, because when you go through these cases, you can come to any of these points and point out the pressure at the time of placement or renewal or of changing insurers where something has gone wrong. All right, so let's go about when you get to a position where you're actually changing insurers. This is a recent decision. Ground Gilby Limited and another versus Jardine Lloyd Thompson of the UK. Now, it concerns the Camden market in North London. People been to the Camden market? Yeah, that's right. As I remember it anyway, it's about 5 times the size of the Melbourne market. It's a maze of people and coats and stuff everywhere. JLT was first instructed on a new account for the Camden market in March 2005. At that time, the cover was with AXA. JLT had the market surveyed by Fusion Insurance and then moved the cover from AXA to Fusion in March 2005. Now, Fusion's quotation at the time, just the quotation, said that portable heating appliances, or LPG ones, or ones that have got an exposed filament, should be removed from the market because of the fire risk. Now, the obvious problem for the owners of the Camden market is that the stall holders are not employees. Right? They're independent contractors. And has anyone been to Camden market in winter? It is cold. Right? It is really cold. So people want to keep themselves warm, and the market and the insurers are saying, tell them to remove the portable heating appliances. Right? So they've got a major compliance issue to police. How do they actually do it? How do you stop someone from bringing one in to keep themselves warm because they're absolutely freezing? And so there was a pre-renewal survey in March 2006. Something Gary will talk about a bit is that obviously at the time of their appointment they extended out the cover placement to May 2005, so they had a period of hold covered. Not that that was particularly relevant. But there was a pre-renewal survey in March 2006 and then the cover renewed in May 2006. And at that time, Fusion reported concern as the continued use of PHAs by the traders, right? So at the moment, it's an issue going back and forth, but you know what you're thinking of brokers. You're saying, yeah, okay, telling them they're trying to police the policy. Insurers complaining about it, but brokers thinking, well, okay, you're complaining about it, they're doing their best, you're still underwriting the risk. But then we had a significant change. After being on the policy for 2 years, there was correspondence in March 2007 regarding the implementation of a survey condition. And what Fusion was really saying at this point was, you are not policing the removal of the PHAs sufficiently, so we're now going to warrant the policy. We're going to put an endorsement on the policy in relation to damage caused by PHAs. And the policy was so endorsed in the material that was sent over in March 2007. Now, as a theme that runs across a lot of liability cases against brokers, this shift from a discussion to a serious policy endorsement was overlooked. Right? There was debate about the on the facts as to how much it was discussed, but certainly there was no email or advice in writing about the new policy endorsement that as a defence lawyer I'd be looking for. And so the insured had made attempts to prevent the use of PHAs, but was not made aware of the survey condition, which I'd call an endorsement, on the policy. And as luck would have it, there was a fire on the 9th of February 2008 caused by you-know-what, a PHA, and Fusion denied indemnity. Now, the UK doesn't have Section 54 of the Insurance Contracts Act, but denying indemnity by reason of breach of a policy condition is always a bit difficult. You have to show under Section 54 that the breach of the policy condition was the direct cause of the loss. You've got to show the breach of the condition caused the prejudice. So if the breach of the condition is the cause of the fire, then the insurer can deny indemnity. But it's difficult, right? It's contentious. And in this one, on legal advice from a senior counsel, the claimants or the insured went to Fusion and negotiated 70% of the recovery, which was a bit over £3.5 million, and they were left with 30% uninsured, right? Which was close to £2 million by the time we got to trial. Now, the decision went against the broker. And to be honest, finding a case where a broker's won is a bit of a struggle. I certainly couldn't find any recent one. And whilst JLT had advised the insured of their significance of the use of PHAs, it had not specifically advised as to the impact of the policy endorsement. That it hadn't actually said this is now elevated to a policy condition, it will compromise your cover if a PHA causes a fire. That was the advice you wanted to see in writing. It wasn't there, right? And this was held to be a breach in duty and cause of the claimant's loss, and the settlement was reasonable, and JLT was ordered to pay the 30% balance, which was interest was about £2 million. So what really is the take-home lesson in relation to this? Well, this is a summary from the case. It's also in the paper, but I'll just read the part that's actually quoting another case at the bottom in italics from HIH Casualty in General and JLT Risk Solutions. Longmore Lord Justice said, an insurance broker who, after placing the risk, becomes aware of information which has a material and potentially deleterious effect on the insurance cover which he has placed, is under an obligation to act in his client's best interests by drawing it to the attention of his client and obtain his instructions in relation to it. Now, obviously, renewal is the high-risk area, and if something new pops up on the policy, like an endorsement or condition, right, this is like the takeoff or this is like the landing. Absolute focus. What's it mean? How is it limiting the cover? My client has to know about it. Can we negotiate its renewal? And it's got to be in writing. Don't miss-fail. Do it every time. You'll never have any trouble. That's what best practice is about. All right. Now, new accounts, new troubles. Again, it's another case that Gary's spoken about extensively, but Strategic Property Holdings and Austbrokers RWA. The plaintiff, Strategic, had a property portfolio in the ACT, and the second plaintiff was the manager. And the particular property out in sight was a large building known as the Australian Defence Academy. From the period of 1 July 2005 to 22 May 2006, the ISR policy moved to Suncorp as part of a consolidation of their insurance portfolio. Now, for those of you, who actually breaks ISR in this room? Anybody, or are all financial lines? All right. Look, there are other people at DLA who do a lot of litigation about ISR policies, but as you know, there are declared perils. And in this case, the declared value of the site for the usual perils of fire, etc., was $22 million, but there was a sub-limit for accidental damage of $200,000. Right? Huge difference. On the 3rd of January 2006, roof of a building collapsed, causing significant damage to the property worth some millions. Suncorp sought to rely on the $200,000 sub-limit, claiming this was accidental damage, and they were successful in relation to that. And in relation to the decision, the case in negligence was brought against the broker, and the claimant advised, or the insured, saying, well, look, we just wasn't drawn to our attention that this very significant risk was so significantly sub-limited. We thought we had cover for $22 million. Accidental damage, that's exactly what happened. We expected there to be cover for it, but because it wasn't a prescribed peril, we didn't get the cover and we just didn't understand it, and the court accepted that case and said that the broker had a specific duty to advise of such a significant restriction in cover as concerning a sub-limit. So the broker ended up paying many millions of dollars, or more importantly, their E&O insurers. So what's the take-home message from that? Well, it's pretty clear. I mean, you've got to treat sub-limits with care, right? A sub-limit is a specific risk that the insurer does not want, right? A specific category, and when you've got such a disparity between the other declared values and this particular sub-limit, client has to know, and it just has to be in writing, right? None of this discussion I told them about it, right? Policy endorsements, sublimits like that in writing on the file, don't misfile, right? It is pretty simple, but that's what best practice is all about. Okay, the third one, another recent case in Australia, Horsell International and Dive 2 Proprietary Limited. And this concerns scheme policies. Who breaks scheme policies here? Over the few of you? Really, only one? I don't believe it. Thanks. All right. The particular risks involved with schemes, the main reason being that there's just a lot of members of the scheme, and these accounts can be profitable. They can rapidly go to unprofitable if these people keep making complaints and queries. In this one, Dive 2 was a scuba diving business that was insured under a scheme master policy organised by the PADI. I can't quite remember what PADI stands for. It's something to do with diving instructors, some association of diving instructors. What's the P, Jack? Pardon? Professional Association of Diving Instructors. Gotcha. All right. So if you want to learn how to dive, go to these guys. The brochure marketing the scheme made these disclosures under the heading Common Questions. Does the public liability policy cover the liability of the dive boats we own and operate? Answer only if the vessel is under 12 metres in length. And I've highlighted the next bit. Most boat policies have a separate liability coverage. All right? Horsell International can arrange insurance for vessels over 12 metres in length. Now, in response to that, Dive 2 made a request for coverage for their boats. Right? But then no mention of exclusions was made, and they didn't actually go ahead with the separate coverage in relation to their boats. And I think notably that the court certainly made a lot of this. The brochure did not actually set out, the advice about common exclusions, right? Or didn't do it to sufficient detail. And so you didn't really have that sort of a chart at the end saying what the common carve-outs were for. Now, as you would expect, there was a boat owned and operated by Dive 2 crashed into a fishing boat, causing serious injury to a Mr. Lane. Dive 2's employee was charged and convicted of an offence of dangerous navigation under the Crimes Act 1900, New South Wales, and then the cover was denied by the insurer because of a criminal acts exclusion. The insured then sued. Now, saw a few people smiling about the criminal acts exclusion. It's one of those sort of exclusions that if you really leaned on an insurer, they'd remove it. I mean, it's a bit like saying, if you're caught speeding in aquatic terms, then there's no cover in relation to a car policy. So, it was a bit of a old exclusion, but successfully denied cover. The court held that there was a breach of duty by the broker in not drawing the exclusion to the attention of the insured, and it was relevant that a standalone public liability policy at a higher price would probably not have had that exclusion, or at least such a policy was available in the market. So again, another broker goes down. What's the take-home messages from those ones? Well, first one is scheme policies are definitely risky. There are many members, and one member that makes an inquiry is owed the same duty as any other, right, for a very low margin. So that can make it unprofitable. It's also very risky because you're unlikely to give them the attention that the courts are really going to say they deserve. The answer to it is obviously structuring the scheme properly and really thinking about your processes as to how you are going to manage separate requests. Regularly review it, make sure that the members are aware of any exclusions. It's certainly high risk when the scheme feeds into individual lines, and carefully record in writing queries made by members as to the scope of cover, and always deal with exclusions in the marketing material. Don't sort of gloss over the limitations. All right. Now, I've just got two more cases. One that's on the one I'm going to talk about. Then I'm going to finish with the life insurance case, and then we're over to Gribbo. This one is pretty straightforward. Cockcoo Bread Proprietary Limited v. Vero. I don't think anyone would recommend the facts of these as best practice. It was an online proposal form completed by a broker on behalf of the client. The client owned a bakery. The broker was OIB, and he placed it. Cover was placed with Vero. There was a question in the proposal form. Has anyone answered this question in the proposal form? All right, lots of nods. Regarding the amount of sandwich paneling, extruded polystyrene, did I get it right, Gribbo? EPS, containing the internal construction of the premises. And those familiar with that proposal form know that you can tick sort of 4 boxes: 0 to 33%, 33 to 50, 66 or something, 66, and then and then the last one says we'll detonate just because you look at it. And so the broker ticked 0 to 33%. I think because they were thinking I didn't know what EPS means. So it can't be there, and the premises was destroyed by fire on the 19th of August 2010. And when the loss assessor went through, they said there's more than 33% EPS in this building, and Vero denied indemnity, and Kotku sued both Vero and the broker for the loss, which was $2.7 million. Now, the concession made by the broker in cross-examination, and I can't believe that this was ever the broker's instructions to the lawyers, but certainly the way the evidence came out was the broker conceded that they had no instructions in relation to the question as to how much EPS was in the building, right? That they actually ticked 0 to 33% as a guess, just thinking that was what the answer was, without actually confirming instructions, and that they didn't actually confirm the instructions as to whether or not any question that answered in the proposal form was actually correct. There's probably a lot of reasons for that, but there for the grace of God go a lot of us probably. So the take-home message in relation to that is that it's pretty unsurprising that the court found against the broker in those circumstances, but also held that Vero was entitled to deny indemnity for the misrepresentation in the online proposal form under Section 28(3) of the Insurance Contracts Act. So what's the take-home message from that? Well, pretty simple one. If you're completing online proposal forms, don't make up the answers. Get some instructions. Always act on instructions and record them in writing. Cut corners if you're comfortable running around the seconds or have a particular affection for the named defendant. All right, now finally, just my last case before I'm handing over to Gribbo on time. It's just in the paper, and you might actually just want to have a look at it because it's, and I haven't, because it is one worth reading. Very unusual set of circumstances. I will quickly skip through it. Mr. Swanson was an architect, a professional person. He had cover with AXA for life insurance that covered him for about $1.7 million. In March 2012, he got his renewal terms. He was currently with AXA, and the policy premium had gone up by $800. That market's under a lot of price pressure at the moment in terms of claims. A lot of them apparently psych-driven, which is about 40% of the portfolio, I'm told. Consulted with his broker, Mr. Harrison, about other options. He said AIA is cheaper. I can save you $800. They had a discussion. Justice McCauley held that it was held that Mr. Harrison did adequately advise as to Mr. Swanson's duty of disclosure. Asked him how you're feeling, and he said, well, as it happens, I saw the doctor yesterday. I've got a bit of a stomach complaint. The doctor gave me antibiotics and thought it was Giardia. And Mr. Harrison said, oh, that's fine. And then he put in place to shift, made a note, Giardia, that sort of stuff. Prepared the policy that was placed with AIA on the 21st of March, and then let the cancellation of the AXA policy go on the 28th of March. Somewhat tragically, in the meantime, Mr. Swanson's pain did not go away, and then on the shortly prior, on the 13th of March 2002, he sought further medical treatment, so 6 days after, was diagnosed with pancreatitis, and then an MRI scan was performed on the 22nd of March and made a diagnosis of terminal cancer. Tragically, he didn't tell Mr. Harrison about that, and the policy was allowed to lapse. And so when the claim was made, and the claim was made after the 28th of March, AXA successfully avoided liability because the policy had been cancelled, and then AIA denied indemnity and did so successfully on the basis of non-disclosure. So Mr. Swanson sued his broker. Now, in a very long judgment, and this was just handed down a week or two ago, Mr. Swanson is not long for this world. On an accelerated trial, he's got a wife and 3 children. The court actually found against the broker, but only in relation to not following up as to how his stomach complaint was going between the 7th of March and the 28th of March. All the court actually held that the broker had a duty to just follow up before you actually chop the old policy, of which no duty of disclosure applies in relation to the renewal, to go to a new policy where the duty of disclosure does apply, that there was a breach of duty in not making an inquiry in relation to such an important time as to how Mr Swanson's health had been going in the meantime. Similarly, the court held that Mr Swanson had been 50% contributory negligent in relation to not going back to his broker to tell him about the diagnosis of pancreatitis on the 22nd of March. Now, pancreatitis doesn't mean you've got cancer. The cancer diagnosis did come after the exit policy was cancelled. Now, so it's sort of a salutary lesson about best practice because, again, that absolute focus around the time of changing insurers. And so I think the question I'll leave everyone here with is best practice clearly requires a particular intensity around renewal dates, particularly in those circumstances. And I think I'll leave it to everyone. In a similar situation, would you have diarised the date and made a call on to Mr Swanson to check out how his health was going before the policy was cancelled? Best practice would have ensured that you did, and Mr Swanson and his family would be in much better circumstances than they are at the moment. So, what are the key messages? Clearly, know your client's business. Verify your instructions. Don't make guesses. Communicate key limitations and alternatives. Take particular care around endorsements and sublimits. Your insured has to know what they are. Explain, confirm in writing. Make sure your client is aware of key exclusions. Be sure to keep records of potential claims and circumstances, and Gary's going to talk a lot more about those. I haven't as much. Be sure to keep good files and give yourself enough time to renew them. Because best practice makes your clients and your insurers your raving fans. And if that's what you've got, that will more than look after the legal risks. Thanks very much, everybody.
David, thank you indeed. Good morning, everyone. A lot of old faces here. Very happy to see those. Thank you for coming out so early in the morning. What I want to talk about is to bring up the particular aspects of best practice as they relate to professional risks broking. David's dealt with the general. Let's now particularise it. There are three areas, of course, that are predominant in which best practice is required. The placement of business, whether that be new business or shifting business, the renewal of business, and of course in the area of claims management. In terms of the placement, the key areas where a broker needs to be fully informed and absolutely sure of the facts on every single occasion, and where appropriate levels of documentation and communication are essential, are these. Obviously, the business and its structure. An experienced professional risk broker like Greg Hansen will tell you that it is absolutely critical to have a clear, unambiguous understanding of the business and of the business structure. It's critical that you have a complete depiction of the professional services being provided. There are inevitably wrinkles in even straightforward professional activities. Little things at the margin that may require within the schedule itemisation as a specific professional service being offered. So what is the range of advice? Make sure that it's properly and fully described. The contractual liabilities. We live in an age where litigation is abundant, where the demands of people for their contractors and their providers of professional services are ever increasing. Indemnity provisions, hold harmless provisions, limitations of subrogation. All of those need to be properly and fully understood if gaps in cover are not to be left. Obviously, the claims history. Good underwriters understand the distinction between a fine reporter of possible circumstances and a recidivist provider of professional services. Some clients are excellent reporters, others are recidivist. But you need to be documenting and reporting clearly to insurers a complete, unabridged claims history. It's not for you as brokers to be forming judgments. Your role in this matter is as a collector of information and a conveyor, a communicator of information. David has harped in the general area on policy features. Within professional risks, those are very onerous indeed. You need to understand fully the covers that you're recommending and to communicate with your client particular policy features. Within professional lines, the most basic of those is, of course, the claims-made format of cover. I've said it before to a great many of the people in this room. Simply because someone is an experienced, well-educated, intelligent, professional practitioner does not mean that they understand the distinction, the essential difference between an occurrence-based protection and a claims-made format. It is fundamental, it needs to be explained, it should never be assumed that a professional person who happens to be your client understands that distinction. Almost inevitably, they will not. It's true of lawyers, it's true of architects, it's certainly true of accountants. In terms of business and business structures, it is imperative that you ensure that the correct entity is noted as the insured party. Particular problems tend to arise in a number of professional services areas, particularly in medical malpractice and the practice of medicine generally, where there is almost inevitably a trust entity and a service company which is providing employment and contractual relations at the coalface. You need to understand and discuss with your client precisely where liability in a professional sense may fall and where legal action may be pursued to ensure that entities and individuals who may be actioned are in fact named and properly protected. The professional services being provided, I stress again, you must in all instances ensure that the professional services are completely described, are clearly described, that your understanding of them is complete and clear, that there is no ambiguity, that there is no gap into which you will fall and have to resort to your professional indemnity insurance. At the end of the day, best practice is about risk mitigation for you and your businesses. It is about avoiding the worst excesses of professional indemnity exposures as professional risk advisors. Up-to-date resume should always be requested, whether at renewal or in the instance of first closing business. Particularly true, of course, for sole practitioners and for small entities. Understanding your key customers, the key customers of your clients and their contractual issues is imperative. Any of you who have mining consultants or engineers as clients will be aware of the particularly onerous contractual terms of engagement utilised by mining companies as an example. Contracting with governments, whether it be local, state or federal, is always fraught with issues because of contractual limitations, extensions of liability contractually, emphatic impositions of liability, strict liability, that go well beyond duty of care issues, and of course limitations of subrogation. An SME broker, for example, wholesaling into London through one of the majors, needs to carefully inspect the terms of engagement, the terms of trade. Companies like Willis, as an example, and Aon, if you're wholesaling through them in London, have contractual capping of their liability. It may be that that contractual capping applies over several years of services. Your professional indemnity insurance, I can assure you, whether you be a Steadfast, Ostbroker, IBNA or NIBA professional indemnity scheme member, does not automatically extend to protect you. So anyone here who has terms of engagement with London wholesale brokers needs to check those very carefully because it's become contemporarily a real issue. Again, obviously in relation to claims and circumstances, in the first instance and at renewal, there is a need to refresh information to ensure that a complete history of claims and of events which have occurred which are likely or possibly will give rise to liability in the future. The mantra is inquiry, inquiry, inquiry. It's all about asking, and having asked, it's then about recording. When push comes to shove, the only defence you will have as professionals is if your practice is embedded, and if on every occasion where there is a communication, an exchange of information or receipt of instructions from a client, you are documenting. Contemporaneous documentation, file notes that are done that day that are as complete in their nature as they can possibly be, will form the principal plank of your defence in the event of any assertion that you've failed in your professional duty, whether that duty is in respect of negligence or in respect of contract. The critical policy features need to be explained properly and a record kept of those exchanges. The claims made matter I've referred to, the implications of claims made format are abundant and they need to be made palpably clear to your clients. The requirement for retroactive cover, an explanation of the continuity provisions commonly contained nowadays. And where switching policies, of course, you do need, as a matter of best practice, to document discussions with your client about the abruption of continuity and to discuss with your client whether there is a need for continuity, beyond, of course, registering the fact that you have discussed with your client the need to notify all possible circumstances which may conceivably give rise to a claim to the expiring insurer. The need for run-off cover is critical. Best practice, you must not ever accept, at first blush, instructions from a client to terminate a professional liability contract until such time as you've explained and again documented your explanation, established contemporaneous evidence of that discussion about the need for run-off cover. If a service has been discontinued, it should not be removed from the schedule. Financial planners, for example, are no longer recommending a great many MIS products, but their liability will continue because the tort of negligence has a 6-year statute of limitations in all states except Tasmania. So where a client is a sole practitioner, a sole trader, the need for run-off cover is absolutely critical. It has to be explained and cover should be purchased. If it's not being purchased, then you need a very, very strong defensive position to avoid any possibilities of liability yourself. Clearly, the excess needs to be explained, whether it's a cost-inclusive or cost-exclusive excess, and how it is to be paid in the event of a loss. Renewal, as David has highlighted, is a period of risk. As brokers, the tendency, of course, and as insurers, is to think that renewal is very low cost, easy, convenient business, and that's true. It costs a great deal less to transact renewal business for all parties in the insurance value chain than to be transacting new business. But there are risks, and those are abundant in the professional risks environment. You need to refresh information. So best practice is to start professional indemnity, directors and officers and other professional risk class renewals 2 months early. It's at that stage that the first communication and contact should be made with the client if you don't have a regular routine of meetings and discussions. You should, in that period, certainly no less than 6 weeks in advance, be refreshing all the information with the renewal questionnaire, ensuring that you have put your client on warning about the need to advise of any changes in the professional services being provided. All professionals are like other businesses. They're looking to expand the raft of revenue-generating activities that they undertake. At the margin, we all want additional income. It's a natural tendency. Organisations and businesses are organic, therefore they want to grow. If they're not growing, they're dying. That does, for a great many professionals, suggest that they will be expanding at the margin the raft of professional services. Ensure that you have asked very directly the question, has there been any change? What is that change? Be sure that you understand it. Update all other important information. make the specific inquiry about circumstances. Critical to professional risks, as I think to all classes, but particularly so in professional risks, is that renewal must be effected on time, in time. Extensions are notoriously dangerous. Held covers in respect of professional risk exposures are diabolical in terms of the contemplation of potential risks that confront you and your clients. It is then critical to embed as a practice within your business the early negotiation and commencement of renewal. If you're changing insurers, a formal documented process should be in place. All review discussions need to be recorded. Again, I make the point, in the event of a professional indemnity matter arising, your only defensible position will be the quality of contemporaneous file notes and records. Without those, you're going to court with absolutely nothing available to you in respect of defence. Notifications to expiring insurers of any possible circumstances which might give rise to a claim. A clear explanation, again documented, of the continuity clause, of the consequences of moving insurers, and obviously negotiation with the incoming insurer of continuity provisions. Ensure that cover is maintained for any discontinued services. And again, in all respects, ensure that there is full and complete documentation of instructions, of discussions, of any understandings that have been reached between yourself and the client. In relation to claims management, the natural tendency of people is to act as nice, intelligent, warm human beings. Someone is distressed, so we tend to want immediately to provide comfort. In professional risk matters, do not do it. Do not provide an assurance to your client that everything will be okay, that they will be in receipt of an indemnity. Resist the temptation, the natural inclination to be a kind and warm human being. You must do that to protect yourself. Because as sure as eggs are eggs, Murphy will win every time. If you provide a categoric assurance to your client that they will be indemnified, that everything will be okay, you can almost certainly depend on the fact that that will be the claim that has the wrinkle. It is neither your role nor within your ambit of responsibility, legally or morally, to provide that assurance. That's something for the insurer. Issue clear written instructions to your clients, if it's obvious that a claim is going to occur, about the criticality of not making any admissions of liability, about not making any offers of compromise or settlement, because it will imperil their indemnity. Again, the need is for very clear communication and for full and appropriate levels of documentation. Ensure, of course, when a notification is received, that a client understands the excess that's applicable to the matter and how that's to be funded and managed. Absolutely critical is to immediately notify the insurer. Again, I make the point and stress it, it is not your legal right, nor is it your moral right, to make decisions about whether a matter that's been advised to you will in fact ultimately result in a liability under the policy. That's for someone else to decide. It's certainly not for you. As brokers, your role is simply to be a communicator, if you like, a post office. I want to look at 4 case studies in relation to professional risks. First involves the area of certainty of risk. The second, a failure to notify. The third is a management liability matter. And the fourth, contractual liability. It's been reasonably well reported in the press here in Australia about a large matter in New Zealand involving Apex. Broker's authorised representative arranged D&O cover for a financial institution which was engaged in annual fundraisings. Those fundraisings, being public in their nature, are of course subject to prospectus. The policy, the D&O policy, excluded prospectus liability where the amount being raised exceeded $400 million. The client sought, specifically, full prospectus cover, which it asserted meant cover for all past, present and future prospectuses involved in fundraising. The broker negotiated with AIG. AIG issued an endorsement, the so-called Endorsement 8, which provided cover for some prospectuses, but not all. The broker admitted that it didn't notice that cover written back via the endorsement was in fact limited. The broker asserted that it had sought and that AIG had verbally agreed to provide cover for all prospectuses. However, the endorsement was unambiguous in that it didn't provide cover for all prospectuses. Hanover, the client, and its subsidiaries failed in court action in New Zealand in its bid to have rectification of the contract. That is, they said, this is an error, the contract needs to be rectified. Our understanding and agreement with AIG was that all prospectuses would be covered. AIG, for its part, pointed to the endorsement, which in its wording was unambiguous, in that it was limited, and said, there isn't an error, this was our clear intention. The broker admitted that it in fact hadn't properly read and understood Endorsement 8. So here there was abundant uncertainty of cover. Best practice always would be a clear and unambiguous communication of cover, subject to certainty in relation to what was being provided. This matter involves the mere sum of $38 million, for which the broker is now being sued, and it will certainly settle for something between $25 million Australian and $30 million Australian at current exchange rates. It is a market-leading type professional indemnity loss. The second is failure to notify an insurer. Broker arranged PI cover for a solicitor. Solicitor's mortgage fund was operated by that client. Nice, safe, secure investments. Lend your money to the solicitor will on-lend it. Good rates of return, superior rates of return to putting it into normal financial markets. Very safe and secure, a 65% loan to valuation ratio, leaving plenty of fat in the property value to meet the loan in the event of a default. That was so until property values in Sydney, particularly along the harbour, went through the roof. There were massive increases in property values. There were some very spurious valuations. A solicitor involved notified the broker that there were 3 substantial mortgage loans which had moved into default. At that point, of course, the broker should immediately have notified the professional indemnity insurer. The complication, naturally, Murphy being Murphy, is that that notification happened to coincide with renewal of the professional indemnity cover, and the broker didn't want the complication of 3 notifications, which in his mind were remote in prospect in respect of liability, because there was, after all, a 65% loan to valuation ratio. So if the loans went into default, there was plenty of fat to meet them. No liability would result. Everyone would be happy. The pain and difficulties of negotiating a PI renewal against the backdrop of 3 notifications was removed by not notifying. Properties were subject to mortgagee repossession. In one case, the valuation was reasonable. There was no default on the loan. The other 2 revealed very, very significant defaults. In total, $750,000 was short on one loan and $350,000 on the other. The broker had made the decision that liability would not arise, so guess who ultimately paid the $1,050,000? The broker's professional indemnity insurers. Management liability is contemporarily a potential problem child for brokers and in a great many respects for insurers if they're not careful about how they are operating their business. There are issues that are abundant within management liability. A $1,500, $2,000 premium doesn't mean that it's a simple cover. Management liability is a complex, complicated policy format. It's multifaceted and it has a great many nuances that may give rise to difficulties for you as brokers and for your clients. Typically, private companies operating less than 2 years have difficulty in obtaining cover in respect of insolvency events. After 12 months of profitable trading, it is possible, however, to obtain cover if there's a strong income statement and a strong balance sheet. The question always needs to be asked. In the extant matter, no insolvency cover in the first year. Come renewal, the broker simply went ahead and renewed without having the discussion about whether insolvency cover was required and whether it was available, so there was no market exploration. The absence of contemporaneous file notes regarding that discussion exposed the broker to significant liability, when indeed the company overstretched itself and encountered financial difficulties. During the second period, excuse me, an employee was seriously injured in a workplace accident. The Workplace Health and Safety Authority launched action for breach of the Act against the entity and against a number of directors. A $290,000 fine was levied against the entity, the company. Fines of $220,000 were entered against the directors, whereupon the insurer denied liability on the basis that to indemnify those fines under the statutory liability extension would constitute a breach of public policy. The contention of the insurer was, and remains now, because this is an unsettled matter, that the fines are there as a deterrent. They are a social good aimed at heading off breaches of workplace health and safety, and that therefore to indemnify the entity and the individuals responsible for a gross breach of the Act would confound the deterrent effect and be an offence in respect of public policy. I leave you to divine which insurer it might be. But those of you with extensive years of practice, the 40 or 50 or 60 years of Ray Lundy or Terry Lane, would probably arrive immediately at a conclusion of which insurer was involved in that denial. Professional indemnity, contractual liability. PI cover was arranged for a consultant, a structural engineer who undertook significant work for a large mining company. I mentioned earlier that such engagements are fraught in the respect of the terms of the retainer. Client was keen to ensure that he was fully covered. His broker, having placed a $10 million policy limit with excellent security, assured the client that he was fully protected. The engagement with the mining company was on their standard terms. It included significant contractual liability and indemnity provisions. A dispute arose when a third party was injured on a mining company's site when a building collapsed. The collapse of the building had nothing whatsoever to do with the professional work or a breach of duty on the part of the structural engineer, but under the terms of the retainer entered, the structural engineer became responsible for that matter. The company sought to recover the damages from the engineer. The insurer denied indemnity, and that matter is currently being paid by the professional indemnity insurer. Best practice is about risk management. It's about managing your exposure as individuals, about managing the exposure of your businesses. It's about protecting your income stream, your assets, and in particular, protecting the most valuable thing you have, your reputation. It is a matter that is greater than normal or ordinary reasonable care, as David has highlighted. For a lot of the people in this room, I know that it's how they do their business. I have great regard for a great many of the brokers in this room. You need to ensure that within your businesses, elements of best practice are embedded, that they become part and parcel of your everyday work process if you are to protect that most vital asset, your reputation. Again, thank you for coming out this morning. If you have questions, David and I will be pleased to avoid them. But we're certainly welcoming of questions. David in particular. David, as you'll all be aware, is a self-made man who worships his creator. Do we have any questions? Greg.
Last claim, if the contractual liability exclusion of the PI policy, they could clearly then explain to the client, is that given the brokerage of defence?
Absolutely. Absolutely. But remember that in that case, Greg, the instructions from the client were very specific that he wanted full cover. And there was no record of discussions or of explanations being provided to the client regarding the contractual liability limitation and its consequences for the client.
Yeah, I think it was the second ProRisk seminar we did, actually did a paper on contractual liability exclusions and how to handle them and advise your clients. And certainly these indemnity clauses, particularly in the mining sector, are a huge problem.
All of us have clients every day that look at sign contracts that have whole harmless clauses and have liability clauses going up the shit line.
Yep.
But they all do it anyhow.
Yep.
And it often you can try to explain how PI works, you know, your clients always think.
Yeah.
As long as you've got a defensible position. Your best practice, your defence in those cases is to be able to point to documentation that at regular intervals, at least annually, you've brought front and centre that issue to the notice of your client. In the absence of that repetition and that annual practice of doing that, you will stand exposed.
And look, I think I said it last time. The paper's available on the ProRisk website, and there's some complexity about the concepts. Just send it to your client, and record the fact that they've got it. I mean, that is due warning, because those provisions themselves don't make sense. Like, I've been through insurance indemnity clauses, and God knows what I've done in my life to make myself an expert over such a boring topic. But those clauses are drafted by people who do not understand insurance, and they are terrible. But the clients expect to be covered in relation to them. And, that part of the industry really needs some tightening up. Because consequently, I've seen some insurers endorse risks under those clauses, which is just ridiculous, the liabilities they're taking on. And but if that's current, we can have another seminar on that. But it does go back to the famous case of the collapse, the destruction of the Piper Alpha rig in 1988, and the catering contractor getting sued for $1 billion under a contractual indemnity. So, those clauses matter, and it's a very high-risk area of practice.
Sir.
Question to David. Going back to the building roof collapse.
Yep.
And accident damage.
Yep.
Interesting moment itself as to, obviously there was no structural deficiencies or anything like that. Just to identify why it collapsed. Just a question on notice with that one.
Yep.
$22 million building, whatever the case may be.
Yep.
There'd be a lot of brokers out there that would sort of say, well, a sublimit to apply. The insurer will normally nominate a sublimit.
Yep.
But trying to tie one in with the other, as in, we're almost doing to foresee all possible things that could happen.
Yeah.
Possibly create that.
Yeah.
To tie these two together is unbelievable within itself.
Yeah. Yeah.
And realistically, $1 million might have been the most you could get away with this.
In fact, the $2 million on its facts, that everything turns on its facts. It was very clear in that case that there was a $2 million limit available. That was the maximum available. That's an AD sublimit in respect of the ISO. The client was able to adduce evidence that there had in fact been a loss of opportunity. The client would have paid the extra premium associated with $2 million as opposed to a $200,000 AD limit. All these matters will be couched as a loss of opportunity. But to demonstrate the loss of opportunity, that client had to adduce evidence to the satisfaction of the court, which it was able to do because they had other policies, that they would have bought a $2 million AD limit.
Is that in retrospect, Gary, once the losses occurred?
Well, the client had other policies on footing that included a $2 million AD limit.
And just 200 grand just on that building. But
This was a salutary matter. The broker, under cross-examination, completely disintegrated and admitted that he didn't even know what accidental damage was. It's a senior broker, don't laugh.
and look, under pressure of cross-examination, I've had, when I've had the good fortune, misfortune, whatever, acting for a plaintiff when we sued a financial advisor over a $25 million financial crisis loss, and the Peter Reardon, cross-examining the director of this company, said, I put it to you that is it a complete and utter breach of your professional duty to put this account in the hands of someone who had just recently graduated from university. To which the answer was, I agree. And just thinking, did anyone ask this guy the question before we got to day 10, the trial at the federal court? I mean, those things can happen. But I did laugh when you said in retrospect, right? One of the great unfairnesses in litigation is that everything has a bit of hindsight about it, that we're all so wise after the event. And best practice is just about trying to learn from what, where others have got caught out and just trying to get it back into your practice. But the key thing for this one was there was $2 million available and the client wasn't told about it. All right, any other questions? I'm just warming up.
Well, again, thank you very much indeed for joining us this morning.
Well done, Gary.